It's okay. Hello. Okay.
Hello.
It's okay now.
It's okay now? Yes, okay.
Okay. So I was talking about evidences. They are of mainly three types. In case of oral, they are of three types. One may be direct, one may be indirect, and third is called hearsay. In case of direct, there are suppose this is the condition that this person whose name is Sham, suppose he is the Sham, and he took the axe and cut the tendon or stab the udder of an animal, that is your milking cow. Because the cow has destroyed all his crops, so he tried to cut. Then at that time, who was watching this incident? This person, Ram. So Ram was watching this. So he will go to the court and say that I actually saw the that Sham was cutting the tendon, and this is known as direct oral evidence. In case of indirect, the scenario is the similar, but this Ram is not actually present at that case. But what he saw is that this Sham was carrying one axe and he was looking for the cattle around 4:30 p.m. just before the uh, incident. So in this case, the Ram will go to the court and in front of the judge, he will say that yesterday I saw Sham was carrying one axe and he was very angry and he was looking for the cattle around 4:30 p.m. just before the incident. So this is the indirect oral evidence. Then what is the hearsay? In case of hearsay, the your evidence means the person Ram actually he didn't see that Sham was cutting or stabbing, and he didn't saw that he was angry and looking for that. But what he listened or what he heard, that is your uh, hearsay. It means he was passing. So he was passing by an area where some four or five people were talking about that yesterday Sham cut the tendons or stabbed the udder of a cattle. So based on this, what he heard about these people, he will say in the court in front of the judge that this is the information I'm telling that yes, I was passing some four or five people were talking that Sham cut the tendon yesterday. So this is based on only hearsay. Whatever he heard from the people, he will say like this. But in case of direct, he actually was the eyewitness. He was the actual witness who saw the case and is telling. But in this, it is indirect because actually he didn't see the Sham was cutting the tendon, but what he see that he was very angry, carrying the axe and looking for the cattle who destroyed his crop. That is indirect. And in case of hearsay, he heard something that four to five people were chatting with each other, talking with each other that yesterday Sam has cut the tendon. So these are your direct, indirect hearsay evidence. Comes under oral. And the second category is document, which is nothing but your post-mortem report or your health certificate. Then there is one more term we call witness. There are mainly two types. Mainly, there are two types. One is common or simple, and one is expert, and one is hostile. Three types of witnesses, but mainly these are two because hostile witness may be common or may be expert. So mainly two, common and expert. What is the difference in these two? Common witness can narrate the fact. Expert witness can give opinion. It means the common or simple witness cannot give their opinion. They can narrate the fact, whatever they have seen, they will tell the uh, fact seen by them. So they only narrate the fact. They cannot give their opinion. But expert witnesses are really they are expert. They can give their opinion. For example, there is a radiologist. There is a radiologist. He is expert in radiology. There is a veterinary doctor. He is expert in veterinary field. So these are your expert witnesses. And hostile witness was honest in the beginning, but because of some threatening or it was bought or manipulated by giving some money. So the witness become hostile because somebody has threatened him or they give some money and they manipulated the things. So hostile witness may be your common, they can be threatened, they can be bought by with money, or it can be expert. So these are three types of witnesses. Now our next courtroom procedure. It means now we will enter into the courtroom and will see evidence recording. So courtroom procedures are nothing but your evidence recording. So what is the meaning of evidence recording? It means how evidence is recorded from witness. How the evidence is recorded from the witness. So this comes under your evidence recording or your courtroom procedure. So if we start with the courtroom, hello. So this is
Hello.
our uh, courtroom procedure, which is also called as evidence recording. So in case of courtroom procedure, this is your judge, and on this side you are standing here, and on this side there is one more lawyer. We call it defense lawyer. Defense lawyer. LAW. And this is your prosecutor. Prosecutor. We call it public prosecutor. Okay. Then this is the whole scenario where courtroom procedure is going on. This is the scenario where evidence is going to record. So before recording, the first requirement is first you call the witness. First you will call the witness, and calling of witness is related with your term summon. So we send the summon to the witness and we call the witness. So the witness come after sending the summon or calling the witness come to the courtroom. Then the first step we are going to take, that is your oath. Then after taking the oath, this is your public prosecutor. It means this side, uh, this is the witness, and this is the public prosecutor of same side. So first we go for the oath. Second is a direct examination, or we call examination in chief. This is the second step. Inside the room. Outside the room, first there was calling of the witness, that is related with the summon part. Inside the room, courtroom procedure. First take the oath, then the public prosecutor or the lawyer, which is of the witness side, he will take direct examination or examination in chief. What does it mean? What is the purpose of this examination in chief? In this case, this lawyer will try to collect all the information from the witness related with the case. The lawyer get all the information and this witness will tell all the information related with the case. This is examination in chief. So what happening in case of direct examination or examination in chief, that the witness and the lawyer of the same side, they are talking with each other. The lawyer is asking the question, collecting the information about the case. Once this is over, the more important MCQ for this second step is cross questions are not allowed. What does it mean? Cross questions means this lawyer is with the same side of the witness. He is with the witness, so he will not do the cross questioning. So who will do the cross questioning? Once the direct examination is over, lawyer has collected the information about the case, then this defense lawyer will do your step 3. We call them cross examination. As the name indicate, cross examination means he will ask cross questions, also known as leading questions. The purpose of cross examination, the purpose of asking cross questions to our witness, the main purpose of this is to the main purpose is to bring about the truth related with the case. So he will ask all the questions from the witness, and these questions are called cross questions. The meaning of cross question means these are yes or no type question. These are yes or no type questions. Suppose the witness is your expert witness, a veterinary doctor who has prepared a post-mortem report and he has given the post-mortem report that the animal died because of the anthrax. This defense lawyer take a textbook, ask the expert witness, your veterinary doctor, that these are the symptoms or post-mortem finding you have written in your report. Then tell me which book you have referred. Then he will say that this is the ICAR textbook I have referred. Then the defense lawyer will ask, do you agree that whatever given in that ICR book is totally right? Then the witness will say, yes. Second question, suppose the defense lawyer asks that Whatever the postmortem you have report you have given, that is also correct with your book. The doctor say yes. Then the defense lawyer ask one more question that this postmortem finding is not given in your is okay no. This postmortem finding like splenomegaly is not written in your postmortem report, but it is written in the book. So he will try to bring about all the truth from the veterinary doctor about the postmortem finding of anthrax. So he tried to bring about the truth. He tried to bring about all the inaccuracies. Suppose the splenomegaly, the postmortem finding, is not written in the postmortem, but it is written in that standard reference book. So he will ask that this splenomegaly is not written in your postmortem report, but as per the book, it is there. So do you think that your postmortem report is right or wrong? So he tried to cross question and the doctor will say yes or no. So these are called cross questions, leading questions, and these are asked by the opposite side lawyer, not same side lawyer. Same side lawyer examination is if we do this examination in chief, he will ask that what was the death of the what was the cause of the death of this chief or goat. He will say it was the anthrax and something other. But this defense lawyer, he will cross questions about the same thing. So we done with our first step taking oath. Then your side lawyer, examination in chief, direct examination, he will ask direct question. Then third condition, your cross examination. The lawyer standing cross side will ask cross questions. Then once this cross questioning is done, then the next step is re-examination. The next step is re-examination. So this is your witness. This is your public prosecutor, your side lawyer. First will take the oath, then he will ask the questions, collect the information about the case. Then this is your cross examination, he will ask some cross questions. Then the fourth point will be your re-examination. Who will do the re-examination? This, your side lawyer. He will ask some more questions. What is the purpose of this re-examination? Just to clarify some doubts. Just to clarify some doubt. Number 4 point. Number 5 is your judge. We call them court questions. If the judge want to clarify something, he can directly ask to the witness. These are called court questions. So within 1 second, the courtroom procedure, the evidence recording. First, we call the witness by sending someone. Then this is the judge sitting in the court. This side is your public prosecutor. This is your witness. And this is your defense lawyer. First, we'll take the oath. Then he will ask the question number 2. Then once he has asked, then number 3, he will cross examination will ask question. Then again he will ask re-examination. If he is cleared, everything is cleared, and at the end, judge may ask. That called court questions. So there are 5 steps: oath, direct examination, cross-examination, re-examination, court questions. And this ended our courtroom procedure. So in this lecture, we did IPC, CRPC, there is punishment, there is definitions, procedures, then we look at the evidences that may be oral, document. These are 3 types: direct, indirect, hearsay. And after evidence, we look for the witness that may be common, may be expert in any professional field, like radiologist in radiology, cardiologist in cardiology, and veterinary doctor in veterinary field. After looking at witness, We take this witness and start recording. Recording of what? Recording of evidence. That first we do oath, then we the same side lawyer will ask direct question. So we call direct examination. Opposite side will ask cross question. So we call cross examination. Then fourth is re-examination, and fifth is your court questions. Court questions. So this was about the legal system which is in India. That is your legal system. That was your IPC. Section P for 5, 1 for 1, 511 section. And that will give you two things, definition and punishment. But CRPC only tell you about the procedure of punishment. So this was after this in this chapter, other things are very simple, and they are just remembering the date like Wildlife Act 1972, 73, Tiger Reserve, and there are many. But this legal system is the important part to understand. And then we did our types of court, where at the top we have Supreme Court, High Court, and there was Session Court. We divide the Session Court into two senior, three junior. What are those junior? Second class JM, first class JM, and chief judicial magistrate, and your assistant professor, like your assistant session judge and your session judge. Session judge. They can give punishment 1, 3, 7, 10, unlimited. 5,000, 10,000, unlimited. It's very easy. Your three junior, two senior, High Court, Supreme Court. These two are court of appeal, and this is the session court which can which can take any kind of case, but these are for only for appeal. They will not take at the beginning all the cases, whether it is robbery case, kidnapping case, rape case, murder case, start with the session court. And that depend on the type of punishment. Suppose there is one rape case, and rape case is having punishment of 10 years. So that rape case will not enter into these three junior what you call judicial magistrate room. It will directly come with the session judge. Suppose there is perjury, that is 7 years punishment. It will not enter into these juniors. It will enter into your chief judicial room. So based on their power, the court, the trial, the case, robbery, kidnapping, murder will enter into these rooms based on their power. Because this is second class judicial magistrate is the junior one in your BVSC and AHS, like first year student having no power, just having power of giving imprisonment up to 1 year. So it is like first year junior. As they keep on moving, they promoted second class, and like this they become more senior. So in case of uh, these two, there are two terms. One is judge does not equal to judicial magistrate. Judge means the person which is senior, and judicial magistrate they are the junior. So this ended our lecture on legal system, IPC or